Assalamualaikum warahmatullahi taala wabarakatuh. My name is Shah Kamaluddin. I am the arbitrator for our arbitration session today. For the respective of the claimant parties, Jendinal and Sofitra, may I know what is your name, Miss? Miss Atika Azharan. Alright. Thank you, Miss Atika Azharan. For the representative of the respondent parties, Vincent Tan Chi Yon and Central Malaysian Properties Sdn Bhd, may I know what is your name, Miss?
Aisyah Sufia.
Alright, thank you, Miss Aisyah Sufia. While most of us may have a rough idea about what court proceedings are, not many may be aware of an ADR process known as arbitration. While sharing the same objective as court proceedings, mainly the aim is to resolve a dispute, arbitration is a private process that is done without a judge and can even be completed in an office meeting room. Unlike court proceedings, arbitration can only take place if both parties have agreed to have their dispute resolved via arbitration. For example, if there is a dispute arising under a contract, there should be an arbitration clause in that contract whereby parties have agreed to arbitration. Party autonomy is key in arbitration proceedings, which means that parties are generally free to agree on how the arbitration should proceed. Unlike court proceedings, parties can agree on the arbitrator, which is the person who will decide the dispute, the language of the proceedings, what arbitration rules to apply, and other factors. Unlike the court process, arbitration is often viewed as being less formal due to the concept of party autonomy as described above. Parties do not have to deal with the formalities and technicalities of a court process such as courtroom ethics. The venue of the arbitration can take place anywhere, for instance, one party's office or a rented meeting room such as in a hotel or the premises of the Asian International Arbitration Center AIAC. The person who presides over an arbitration proceeding is known as an arbitrator, which is me, and I am not a judge. Depending on the arbitration agreement or the rules of arbitration that are adopted, the arbitral tribunal can consist of either a sole arbitrator and an odd number such as 3 arbitrators or 5 arbitrators. There is no requirement for an arbitrator to be a lawyer, a judge, or someone legally trained. Parties are free to specify the qualifications and expertise required. For example, if it is a construction dispute, parties may agree that any arbitrator appointed should have engineering qualifications or minimum number of years of experience in the construction industry. As for myself, I am a USIM engineering alumni and has been practiced for 20 years in this field. Back to the topic, this is different from court proceedings, whereby the selection of the judge during your case is randomized and you cannot select or impose preconditions on the judge qualifications. If parties cannot agree to the arbitrator, it is also possible to have an independent third party, such as the Asian International Arbitration Center, appoint the arbitrator. As well as we all know, this arbitration session is held to settle the dispute between Jendinal and Sofitra against Vincent Tan Chi Yon and Central Malaysian Properties Sdn Bhd. Am I right? I was informed that the dispute arose due to the delay in payment of land reclamation project in the part of the respondent, Vincent Tan Chi Yon and Central Malaysian Properties Sdn Bhd. Then the claimant had terminated the contract and proceeded to refer the dispute to arbitration today. Okay, so without further ado, let's hear the submission from the counsel for Jendinal and Sofitra. Miss Atikah Azhar.
Assalamualaikum and very good afternoon to Aisha and Miss Aisha. As for the introduction of both parties' company, Jan D. Now M. Sniperhead or JDN was a private company limited by share, incorporated in Malaysia, and Jandina Group, also known as Safidra, was the ultimate holding company of JDN, incorporated in Luxembourg. Central Malaysian Properties Sdn Bhd or CMP was a private company limited by share, incorporated in Malaysia. Central Malaysian Properties or CMP was the developer of project for reclamation of land. CMP awarded the project to JDN for its construction. Safidra was the grantor, granting the due performance by JDN of its obligations. Vincent Tan was a substantial shareholder having a controlling stake in CMP. The relevant contract was executed by the JDN and CMP on 23rd of March 2010. Works could not start as planned due to CMP's delay in meeting its initial financial and payment security obligation. Works only started on 8 October 2010 after Vincent Tan executed a guarantee agreement in his personal capacity, guaranteeing the due and factual performance by CMP of its obligations under the contract. By the end of October 2010, CMP was again in default of payment under the contract. Unfortunately, on 12 November 2010, much of the reclaimed platform gave way and moved southwards, resulting, among others, in the loss of one life. This is known as the RFI disaster. On 16 November 2010, JDN issued a notice notifying CMP that it had defaulted in its payment progress. CMP failed to remedy the default. On 2 December 2010, JDN terminated the contract. Now JDN and Safidra agreed to refer the dispute to arbitration.
Okay. Thank you, Ms. Atikah, for the brief explanation and the problem statement. Now let's hear from the counsel for Vincent Tan Chi Yon and Central Malaysian Properties Sdn Bhd, Ms. Aisyah Sufyan.
Assalamualaikum and good afternoon to Aisha and also Miss Atikah. So thanks to Miss Atikah for the introduction of our company background. It looks like you know our company very well. So it's true that CMP has awarded the project to JDN for the construction. Since we know that JDN is a very huge and well-known construction company in Malaysia. However, CMP's delay in meeting its initial payment, financial and payment security obligation, and a few times before in payment was happened out of our control. There was a conflict occurred in a company due to several rivalry cases involving 15 staff. We were always about to settle the payment to JDN, but the inner difficulties had forced us to settle the dispute first. Aisha, the action of JDN terminated the contract is invalid since we are not settled the construction yet. Secondly, JDN must be responsible for the RFI disaster which has caused the loss of someone's life due to JDN unsettled construction. Last but not least, JDN and Safidra must be ordered jointly and severally to pay CMP the sum of 2,007,089 ringgit, 318 ringgit, 57 cents in respect of CMP's counterclaim with 5% interest from the date of the award until the date of the payment.
Thank you to both parties, Ms. Atikah and Ms. Aisyah, for the both submission. After hearing all the dispute and claim, I have come into decision that first and foremost, JDN is validly terminated the contract. Secondly, JDN was responsible for the RFI disaster. Third, JDN and Safidra is ordered jointly and severally to pay CMP the sum of 2.7 million in respect of CMP counterclaim with 5% interest from the date of the award until the date of payment. And last but not least, each party shall bear equally all the fees and expenses by the KLRCA and the Arbitral Tribunal. Any one of you who want to say something?
Yes. I think it's not fair. As the company has defaulted in judgment and in payment, we have terminated the contract due to CMD's delayed payment. And one loss of his life in our justice out of our control. We will bring this matter to hand.
Yes, Ms. Atika, you may bring this matter to the High Court by referring to Section 37 of Arbitration Act 2005. The High Court have decided that the Tribunal had determined the legal implication of the contract on JDN's responsibilities, with particular reference to Clause 7.2a of the conditions of the contract. JDN's contention on the issue of excess of jurisdiction under Section 37, Subclause 1a(5) of the Arbitration Act 2005 was baseless. The Tribunal had made a detailed analysis of the parties' obligations from the perspective of risk allocation based on the evidence made available before coming to the conclusion that JDN had breached its obligation to execute the works with due care and skills as required under the contract. That finding by the Tribunal was neither contrary to nor inconsistent with the evidence adduced in the hearing. The parties had sufficiently raised all relevant issues in their respective pleadings. The Tribunal was certainly entitled to come to its considered conclusion after hearing the parties that JDN had breached its obligation under the contract after detailed examination of the relevant clauses in the contract, where the parties had apportioned the risk involved in the scope of the works. The complaint, as alleged by JDN, had failed to meet the requirement to prove that the Tribunal had conducted the proceedings and issued the award in breach of the rules of natural justice. JDN had not sufficiently particularized the complaint recognizable under Arbitration Act 2005. There was nothing to show that the High Court had dismissed JDN's and Sofidra's appeal on the ground that they had failed in the test of patent injustice or manifestly unlawful and unconscionable. Instead, it was dismissed by the High Court on the ground that after reading the records and submissions of the learned counsels, the court did not think it was a fit and proper case for judicial intervention to set aside the award. The High Court had not made any affirmative ruling to apply the test for intervention of the court under Section 37 of the Arbitration Act 2005, and therefore the present court would not be in the position to give an answer to the question posed. The learned High Court judge had made a correct finding that the Tribunal had not strayed from the pleaded case of the parties in their submissions to the arbitration and had not gone beyond the submissions of the parties. Therefore, JDN's and Sofidra's contentions on the issue under Section 37, Clause 1, Subclause A(5) of the Arbitration Act 2005 to support their appeal was correctly dismissed. The learned High Court judge had also correctly found that JDN and Sofidra had failed to establish their case on a breach of natural justice, and that the award made by the arbitral award was in conflict with the public policy of Malaysia under Section 37, Subclause 1, Clause B, Clause 2, and 37, Subclause 2B(2) of the Arbitration Act 2005. The application of Jan D. Null and Sofidra was dismissed.